Guys, can you imagine this Jamaican-born US citizen who served in the US Army? The government now wants to take away his US citizenship. Now, this is the denaturalization case of Dwyane Robinson. Now, he came to the United States from Jamaica. He served in the US Army. And in 2011, his military service helped him become a naturalized citizen. But in just 2 years, everything changed. Dwyane Robinson was arrested in connection with a shooting that prosecutors ultimately said amounted to attempted first-degree murder. He was convicted, and while he was sitting in jail waiting trial, the Army discharged him under other than honorable conditions, or as we know, it's most famously called dishonorable discharge. Now, more than a decade later, the United States government is asking a federal court to take away the citizenship Robinson obtained through his military service. But here's a part that makes this case different from a simple criminal gets deported story. The government isn't saying Robinson loses his citizenship simply because he committed a violent crime. The legal argument is much more specific. The government says Robinson received citizenship through a special military naturalization pathway, but his later other than honorable discharge meant he did not satisfy the statutory requirements needed to keep that citizenship. And that raises a much bigger question. Can someone who became an American through military service lose that citizenship years later because the service that qualified them for naturalization ultimately did not meet their legal requirements? Today, we're breaking down the case, the law, and what could happen next. According to the U.S. Department of Justice, Dwyane Robinson is a 44-year-old native of Jamaica who later served in the United States Army. His military service became the basis for his naturalization. In 2011, Robinson became a U.S. citizen through military service. That is important because federal immigration law provides special pathways to citizenship for qualifying members of the U.S. Armed Forces. Military members don't necessarily have to follow the exact same residence and physical presence requirements that apply to ordinary naturalization applicants. But those benefits come with conditions. And in Robinson's case, the government says one of those conditions ultimately became the problem. In 2013, Robinson was arrested in connection with a shooting. The Justice Department says he shot and attempted to murder another man. He was ultimately convicted of attempted first-degree murder and assault with a deadly weapon with intent to kill, inflicting serious injury. Those aren't allegations that are still awaiting a criminal trial. The DOJ says those were the convictions resulted from the underlying criminal case. But there is another piece of the timeline that becomes critical to the government citizenship case. While Robinson was awaiting trial in jail, he was discharged from the Army. That discharge occurred on December 31st, 2013. And according to the Justice Department, the discharge was under an other than honorable conditions. And that classification is central to what happened next. Here's where the story gets legally complicated. Federal law provides special naturalization rules for certain military personnel. Under USC Section 1440, a qualifying service member can potentially become a naturalized citizen based on military service during designated periods of military operations. But the statute also contains a very specific provision dealing with what happens if the person is later separated from the military under other than honorable conditions. The law says that citizenship granted under that military naturalization provision can be revoked if the person is separated under other than honorable conditions before completing an aggregate 5 years of honorable service. That's not a 5-year waiting period before citizenship. That's an important distinction. The person can potentially become a citizen before reaching 5 years, but the statute creates a continuing condition involving 5 years of honorable military service. And if the person is separated under other than honorable conditions before reaching that threshold, the law provides a basis for revocation. That is precisely the provision the government is relying on in Robinson's case. Federal law says citizenship granted under this military provision may be revoked under the Denaturalization statute when the person is separated under other than honorable conditions before serving honorably for an aggregate 5 years. Now, put the timeline together. Robinson became a U.S. citizen in 2011 based on his military service. In 2013, he was arrested in connection with the shooting. While awaiting trial, he was discharged from the Army under other than honorable conditions. According to the Justice Department, he had not completed 5 years of honorable military service, and that, the government argues, means his citizenship is now subject to denaturalization. The DOJ filed a case in the Eastern District of North Carolina on July 21, 2026. The government is asking the federal court to revoke Robinson's naturalization. But that distinction matters. The government has filed a case. It has not already won the case. Robinson remains a U.S. citizen unless and until a court enters an order revoking his citizenship. The Justice Department itself states that the claims in these denaturalization complaints are allegations and that there has been no determination of liability. And this is where we need to slow down. Because a headline saying man committed attempted murder so the government is taking his citizenship would leave out a huge part of the legal story. And that's not the government's theory. Denaturalization is not simply a punishment automatically triggered by a criminal conviction. Federal law allows a naturalized citizen's citizenship to be revoked when the naturalization was illegally procured or was obtained through concealment of a material fact or willful misrepresentation. The Supreme Court has also recognized that citizenship can be revoked when it was illegally procured because a statutory requirement necessary for naturalization was missing. In other words, the government generally has to establish a legal defect in the acquisition of citizenship. In Robinson's case, the government is pointing to the special military naturalization statute itself. So what exactly does denaturalization mean? Now, naturalization is a legal process through which someone who was not born a U.S. citizen becomes one. Denaturalization is essentially the reversal of that naturalization when a court determines that the citizenship was illegally obtained or another statutory ground for revocation has been established. Under federal law, the government brings a case in a federal district court. And if the court ultimately grants the government's request, the naturalization order can be revoked and the certificate of naturalization cancelled. The law provides that such revocation is effective as of the original date of the naturalization order. And that's a major legal consequence. But again, that has not happened to Robinson yet. The case is pending. The case also emerged from a broader immigration enforcement effort. The Justice Department says Robinson's case was identified through Operation False Haven, which is an ICE-related investigation focused on people whose citizenship may have been obtained unlawfully. Operation False Haven has been used in other denaturalization cases involving serious criminal conduct. For example, the Eastern District of North Carolina previously announced a case involving a naturalized citizen convicted of child sexual offenses who was later denaturalized after admitting to fraud in the naturalization process. That case illustrates the broader federal effort to identify naturalized citizens whose citizenship the government believes was improperly obtained. But Robinson's case has a different legal theory. The DOJ's public description doesn't accuse him of lying on his citizenship application. Instead, it says his citizenship was based on military service and that his subsequent other than honorable discharge occurred before he had accumulated 5 years of honorable service. And Robinson's case is happening against the backdrop of a much larger federal denaturalization campaign. On August 3, 2026, the Justice Department announced that it filed 25 denaturalization actions between July 20 and August 3rd. The department said those cases involved people accused of offenses including attempted first-degree murder, child sexual offenses, fraud, and other serious crimes. The DOJ also said that since January 20, 2025, it had filed 123 civil denaturalization complaints, which it described as the largest number in recorded history. That makes Robinson's case part of a much larger national immigration enforcement story. But there is an important distinction between filing a denaturalization lawsuit and actually stripping someone of citizenship. A complaint is a government's case. A judge still has to decide whether the government has proved its legal case. So, what happens next? The federal court will consider the government's case. Robinson will have the opportunity to respond. The government will have to establish the legal basis for denaturalization. If the court rules against the government, Robinson retains his citizenship. If the government prevails and the court orders denaturalization, Robinson would lose the citizenship he obtained through naturalization. That could then create immigration consequences because he would no longer have the status of a naturalized U.S. citizen. But we should be careful here too. Denaturalization and removal are separate legal steps. Losing citizenship does not mean a person is literally deported from the country the same day. Immigration authorities would still have to proceed under the applicable immigration law and procedures. And this case raises a difficult question that goes beyond Robinson himself. What happens when someone earns a citizenship through military service and years later the government says that the conditions attached to that military naturalization were never fully satisfied? Supporters of aggressive denaturalization efforts would argue that citizenship must be obtained according to the law. If Congress created a special pathway for military naturalization and attached conditions to that pathway, the argument goes, those conditions have to mean something. But critics of broad denaturalization efforts have raised concerns about the government's increasing use of citizenship revocation litigation and the consequences for naturalized Americans. The legal question in Robinson's case is narrower. The court will have to determine whether the government's interpretation of the military naturalization statute applies to the facts of this case. And here is one detail in this story that deserves particular attention. Robinson didn't become a citizen through the ordinary 5-year naturalization process. His citizenship was tied to his military service. That distinction is what makes the case legally significant. The federal law governing military naturalization specifically contemplates the possibility that a person can lose citizenship after receiving it if the person is later separated under other than honorable conditions before completing the required aggregate period of honorable service. That's why the government's case doesn't depend solely on saying he committed attempted murder. The government is pointing to a statutory condition connected to the very basis on which Robinson became a citizen. And that is a much more precise and much more consequential argument. So, here's where this case stands right now. Dwyane Robinson was born in Jamaica. He served in the U.S. Army. He became a naturalized U.S. citizen in 2011 based on his military service. In 2013, he was arrested in connection with a shooting that later convicted of attempted first-degree murder and assault with a deadly weapon with intent to kill, inflicting serious injury. While awaiting trial, he was discharged from the Army under other than honorable conditions. The Justice Department says that discharge occurred before he had accumulated 5 years of honorable military service. And on July 21, 2026, the federal government filed a denaturalization case against him in North Carolina. But as of today, his citizenship has not simply disappeared. The government is asking a federal court to revoke it, and the outcome will depend on what the court determines about the statutory requirements surrounding Robinson's military naturalization. This case is a reminder that U.S. citizenship obtained through naturalization carries a complicated legal history. And for the people who obtain citizenship through military service, the rules can be different from those governing ordinary naturalization. For Robinson, the question now isn't simply what happened in 2013. It's whether what happened to his military service made the citizenship he received in 2011 legally vulnerable. And that's a question a federal judge will ultimately have to answer. Thank you for listening. to the Social Spectator. If you want the facts behind the headlines without the political spin and without leaving out the legal details, make sure you like, share, and subscribe to this channel, because sometimes the most important part of the story is the part hiding behind the headline. Thank you, and catch you on the next one.